following program is classified G. It's suitable for all ages.
Tonight, we discuss the basics of the law of negligence within Sri Lanka. The conversation on acts of negligence has been long held in the social context of Sri Lanka. This has primarily stemmed from negligence pertaining to the duty of care held by people in positions of power. How has the law on negligence changed over time within our country? What are the lessons we need to learn in the application of the law to create a smoother and more accountable workforce within our country? Good evening and welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and bringing it out for our viewers. Now, negligence, the topic of negligence has been within the public forum for quite some time. When talking about officials, when talking about even private matters of individuals. What exactly is negligence and what is the context that we are dealing with, specifically when it comes to the lens of the law? That is exactly what we are going to break down today, and for that we have an expert in the field, an individual who has been contributing to the field and who has been educating young lawyers for quite some time, President Counsel, Kalinga Indatissa. Thank you so much, sir, for joining us once again. He's the former president of the Bar Association, and this is the second time he has come on our show to give our viewers a very important understanding on this topic. Before we go, we generally give a breakdown to our viewers of where we are going to take this discussion, and that is exactly what I will be doing right now. Firstly, we'll talk a bit about the elements of proving negligence and give you the context as to where the law of negligence came about, what exactly is negligence in the eyes of the law, and then take the discussion forward from that point onwards. Second, we are going to talk a bit about the types of negligence recognized within Sri Lankan law. Third, a bit about vicarious liability and medical negligence, which has been a topic that has come up in the recent past, and finally on the areas of reform that are required in this field of law.
Hi. My name is Johnney De Silva and I'm a data science undergraduate. My question is on elements of proving negligence. How is negligence recognized in the Sri Lankan law and what are its key elements?
All right, let's get into the discussion directly. Thank you once again, sir, for joining us. Yes, it is always a very fruitful conversation when we get to speak to you. Let's get into dive into the topic directly. The question of negligence. Now, it takes multiple aspects when it comes to the layman. What they are more concerned about is holding public officials accountable for negligence, but the topic of negligence is far wider. So where do we start this conversation? What exactly is negligence? How did this law come about, sir?
Yeah, no. Coming back to your question, you gave me two things to think about. The general concept of negligence and also the issue of negligence when it comes to public offices. Now, those are two areas that the public is generally interested in knowing. Now, where the concept of negligence is something that the law that we have it today is something that we have inherited from the British principles and also from South African principles. Now, what is negligence? You know, in courts, in the field of law, we always assess the conduct of an individual from the test of a reasonable, prudent man. In criminal law, it's the question whether the accused has acted in the same manner that a reasonable, prudent man would have acted under similar circumstances. In civil law also, the concept of reasonable, prudent man applies because conduct of a person is viewed, assessed and analyzed through the eyes of a reasonable, prudent man as to whether how he would have reacted, acted or omitted to act in placed in circumstances. Basically, negligence means the omission of doing something that a reasonable, prudent man placed in similar circumstances would have done or would not have done, either way. The concept of negligence is very wide. Normally, we can speak it under the criminal law concepts and the civil law concepts. If you talk about civil law, the objective of civil law is payment of compensation and remedying something which has taken place. So the object of civil law being that the civil courts will always identify negligence by looking at the conduct of the defendant or the person who is alleged to have violated somebody else's right.
Yes.
One of the main things in negligence is that there must be a recognition of a right of the plaintiff. That is the first element. It can be imposed by statute law or common law principles. Now you take an accident, there is no statute dealing with the accident in Sri Lanka.
Okay.
But it generates from the concept of duty of care.
Duty of care, yeah.
Now what is this duty of care? In a general context, there is this famous case, Johnney versus Stevenson, where a lady from Scotland, she went to a cafeteria with a friend and ordered some food and a ginger beer. When the ginger beer was poured to a glass, she found that there was a snail in a bottle. That's a famous case.
Yeah.
That is in 1932. It reported in 1932, AC page 562. That is a very, very interesting case for this concept of negligence. Then she filed action against the manufacturer of the ginger beer bottle. That was Stevenson. So Miss Johnney filed action against Stevenson. In the original court, she won. In the second court, he won. And House of Lords ultimately confirmed the decision of the original court and gave judgment in favor of Miss Johnney. Okay. Now, what came out of this was a number of things were discussed. Number one, there must be a statutory recognized principle or a principle recognized on the common law where I owe a duty towards you. It's not to the world at large.
Yeah.
Second, the first thing in the concept of negligence is that there must be a duty. It is based on duty of care concept. So then Lord Atkin, in one of the most famous judges of England, Lord Atkin made a very important statement. Love thy neighbor. Who is your neighbor? Love thy neighbor and don't hurt your neighbor or injure your neighbor. So your duty, you owe a duty towards people whom matter. So that is what is called in law reasonable foreseeability. Okay. Now say for example, if I am driving a vehicle, there are certain things which has to be in my mind. Yeah. The users of the road, the immediate users, and people who will get immediately affected if I do something which is negligent. So basically the concept of negligence, to answer your question in a general form, concept of negligence means the omission that is committed by a person who has a duty of care towards others. If he has not conducted himself with that duty or with the expected standards of that duty, right, then there is a right of action for the person affected to go to court.
Right. So if you could explain a bit, go into details on the statutory elements that are present in Sri Lankan law when it comes to negligence. And I think something that the viewers would find interesting is what these standards would be when it comes to duty of care, because generally people are aware that there's a duty of care to a certain extent, and then an act of omission would result in a claim of the right of action for the plaintiff. Apart from that, what are the other elements? Like when it comes to, I think my question is, how can a person go to court in general about when it comes to the cases of negligence?
Yeah, in any type of action, now I explain the civil concept. I will come to the criminal concept later. Now any type of action, you can go to a civil court if there's a cause of action. You must have a cause to go to court. Going by the definitions of law in respect of the word cause of action, it must be a denial of a right, failure to fulfill an obligation, neglect to perform a duty, or infliction of an affirmative injury. Now, negligence cases would come under the third limb, neglect to perform a duty. Now, what is my duty? Every user of a vehicle who puts the vehicle onto the road has certain inherent duties to the other users of the road, passengers and other persons who drive vehicles. He has a duty not to be negligent. He has a duty not to be reckless. He has a duty not to be rash. And he must have that duty and exercise such duty with extreme caution and care. Those are the minimum standards. Now, the law expects you to drive in a particular manner on a day which does not rain. That there is no statutory provision which imposes that, but that is the general conduct that is expected from every a driver of every vehicle.
That is understood.
Yes. Then if the road is slippery, or if it's watery, if there is sand, then the driving method is expected to be different to your normal driving method. You have to be cautious. If you are driving around a school where you have children, a populous area, you cannot be driving as if you are driving on an empty road or on a road where there is no other vehicle or no other people. So the standards that you ask me are imposed, are assessed by the courts relatively to the situation and the circumstances. There is no hard and fast rule or statute which says on a rainy day this is your speed, on a sandy road this is your speed. No. There comes the test of reasonable prudent person, whether a reasonably prudent person would have acted in the same manner that the defendant acted. So that is the basic concept.
Right. Moving further, Mr. Indatissa, where are the contentious elements? Now, before I think we are going to cover a lot more within our next few segments, but where are the areas that are not clear, or the areas that usually come to courts when it comes to the issues of negligence? Because we have seen the issues of medical negligence in the past. We have seen, and those cases are quite difficult to, the action is quite difficult. But then there are other situations where people expect quicker results, where when it comes to an issue with a public official. So what are the general cases that you witness in the courts?
I'll answer the last part of your question first.
Yeah.
Public officials.
Yeah.
Public officials are not generally affected by the principles on negligence and the concept of negligence in a general sense.
Right.
But public officials have a duty to perform. They are holding office and they are elected to such office with the assignment of certain duties. So if I am holding an office, I am expected not to just fill up my seat and sit at the table, but you have to take decisions. That is one of the biggest problems in Sri Lanka. Because over the last 40 years, I have seen a collapse of the civil service. I have seen a collapse of the public service. So now it has become a job. Now if you go to the history of civil service, it was identified as a service.
Duties.
During the British, it was identified as a civil service. There were two services, civil service and the judicial service.
Right.
Now it has become a job, which is a wrong concept. So if a public, I'm answering that element, that part of the question, if a public servant is failing to do something, if he takes a wrong decision, there is a remedy called writ of certiorari to quash that decision. But if he is not taking a decision against public inaction, then you can file a writ of mandamus in terms of Article 140 and 141 of the Constitution. You can challenge that. Now, quite apart from that, there are negligent situations. Now, if one goes to, there are provisions under certain statutes which identify the duties of public service. Now, there is an act which was passed in the 1960s, State Liability in Delict. State Liability in Delict. Now, that State Liability in Delict Act will identify the parameters of the duties and the assignment of functions and the nature of duty expected from public servant. So that is that. But quite apart from that, I foresee two big problems here. Now I explain to you, the primary objective of civil law is compensation. From here, I finish this interview, I get onto the road. Some driver comes and knocks me down. Now what happens there? Two things take place. Number one, as far as I am concerned, I have a personal right to sue the driver. Because the cause of action has accrued to me because he has been negligent. Then at the same time, the driver, if he was driving at an excessive speed, under the influence of liquor, without any due regard to human conduct, other people using on the road, one way, you are driving in the wrong direction, then you have committed an offence under the provisions of the Motor Traffic Act also. 149 to 151 sections. If there is death, if I am killed by that accident, on the zebra crossing, on the level crossing, by just smashing onto me, there is an offence under section 298 of the Penal Code for a fatal accident, what we call a fatal accident. Then there is section 328, which refers to injuries caused to an accident.
Right.
One of the biggest problems, we leave the criminal side, criminal litigation out, you go to civil courts.
Yeah.
There is no formula identified with regards to the loss. You can claim two types of losses. One is called the prospective loss, that is called general damages.
Right.
General damages are awarded by civil courts for the loss that you have suffered.
Yeah.
That is loss of a limb, all that. Then there is a second category called special damages. Yeah. That is, you have been knocked down, you could not go for your job for 1 year, there is loss of salary for 1 year, that is income lost.
Right.
Then expenses incurred. You have been hospitalized, you have to pay hospital bills, likewise. So every cause of action where a person can sue another on the basis of negligence, you can claim two types of damages.
Yeah.
One is general, one is special. But the problem is that would the amount of damages would be different. We don't have a formula. Now in England, there is a formula. You lose a limb, there is a minimum, you start with a minimum point.
Right.
You lose a hand, you start with a minimum point.
There's a value given to that.
There is a value given to that. Then it depends. Then there is an enhancement to the value. Now say for example, if I am a cricketer, I am 23 years old or 24 years old, I am on the road, somebody knocks me down, I lose my leg and the arm, right? So you start with the minimum formula. Then they will attribute the importance of my limb towards my livelihood.
Yeah.
And then enhance damages. So there is no, that is one of the biggest problems, because when you litigate in court, it depends on the lawyers on both sides, and they litigate, they argue, and then it's a question of survival of the fittest.
Right.
But if there was a formula, whether I appear for a defendant or somebody else appears,
it's easier.
It is easier, and I think that is the most prudent thing to be done.
Right. I think under our last segment, under reformation also, we can just revisit this, but I think it's a very important idea that you shared. We'll take a very short break. We are in conversation with President's Counsel Kalinga Indatissa. We are talking about the law of negligence. Stay with us.
Hi, my name is Prashani and I am a doctoral student in Finland. And my question is on the types of negligence. What are the types of negligence identified in Sri Lankan law?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Kalinga Indatissa, and we have just passed a segment on the introduction to our topic, which is on negligence. The other area, now the key area, I keep revisiting the topic of public officials. Missing this, I don't know if we are moving away from the subject matter that we want to discuss, but we had issues with, certain, without naming any of those sectors, we had issues with certain consumer products that weren't up to standards, and then people were pushing on those on authorities to take necessary action against those individuals heading those specific organizations. If possible, just we'll visit those areas as well, if you can just give us an explanation. But this segment, Ms. Indatissa, we want to really cover the types that are recognized. Now, it's I think your explanation on the first segment was pretty is very good. On clearing a lot of doubts, but if you could, because the terminology wouldn't be too clear with the layman, so if you could talk a bit about things like gross negligence or contributory negligence, and to tell us what the key areas are, where the key divisions are in Sri Lankan law, and what we should be aware of when we are doing our daily routines, our daily chores.
Yeah, now one of the things that we have to realize is, even though we have inherited certain concepts from the English law principles and then South African law, the area of negligence that we handle in Sri Lanka is somewhat slightly different when it comes to legal issues. The English law is not applied in toto. Right? So it's a adaptation of certain principles. Now, one of the things, if you were going to classify different degrees of negligence is, there is individual negligence, where directly a person liability could be attributed.
Right.
Then contributory negligence is an area which is considered very much in the English law principles. What was the was there some degree of contribution from the victim also towards the incident?
Right.
So you have to assess based, that is where you get the last opportunity rule in England, where who had the last opportunity to avoid the collision if it's a motor accident. I'm talking about motor accidents, I'll get to the other areas in a while. Then you have what is called gross negligence. Gross negligence is absolute. Now you take section 149 and 151. Now in the context of criminal law, generally negligent matters, as I said before, are matters of compensation.
Right.
But if it's a matter between the parties for the payment of compensation, the civil courts will handle it.
Just to interrupt you there, if it's compensation, that will be considered a civil matter, or even in criminal cases, is it going to be compensation?
It is essentially a civil matter, but in terms of the provisions of the Criminal Procedure Code, even in the case of a criminal action, in terms of section 17, you can impose some degree of compensation.
Right.
Not so high as you would claim in a civil action. It's a statutory amount limitation by the enhancing of Fines Act or increasing of Fines Act. There is a limitation placed. Okay. Now, having said that, I must tell you, now we were speaking about different degrees of negligence. Vicarious liability.
Yeah.
Now, what is vicarious liability? That's a very important concept.
Yeah.
Vicarious liability, in other words, can be described as master-servant liability.
Yeah.
Master-servant means you are the owner of the vehicle, you give it to me to go on an errand.
Yeah.
I knocked somebody down, whether you were there or not, whether you were at home or not. Then you become liable as long as I have acted within the scope of my employment.
Right.
But if I go on a voyage of my own,
then
a frolic of my own, then you have to sever that.
Yeah.
Then that becomes my individual action.
True.
So therefore, that is one.
Yeah.
Contributory negligence is where the plaintiff also contributes in some way. Gross negligence is the total.
Yeah.
That is, if you look at section 149 and 151 of the Motor Traffic Act, every action, the manner in which the defendant conducted himself, he has done basically, there is nothing else
he did everything
but gross negligence. Under English law, that is called res ipsa loquitur. It's a terminology that we use. You can see it for yourself.
Right.
For example, if I have knocked down somebody on the wrong side of the road, and if the tire marks show that I have been driving at an excessive speed, there is nothing else it's clear. Yeah. So one of the problems I see is delay in litigation. Right. Now we are under the general concept, a lot of people in Sri Lanka, the public are under the misapprehension that when an accident takes place, the police will take action. You can't do that. The action for damages has to be filed in 2 years. It's a private action. Right. Police action will proceed.
Right. That will be a criminal matter.
That's a criminal matter to punish the wrongdoer, punish the offender. But the person who becomes the victim of an accident case, I'm taking the accident case. Yeah. Just to illustrate, any action for negligence has to be filed within a period of 2 years. That's a prescriptive limitation. Then you were talking about product liability. That's a very interesting area because which has not developed to the extent that ought to develop in this country. Now, you remember, I think about 1.5 years ago, there was a house in Kandy in Hantana which just came down. Yeah. And I believe the husband and wife and the baby were killed. Now who is going to take the responsibility? Who is going to take the responsibility? Is it now, if any wrong approvals have been given, now in Sri Lanka, pardon me for saying this, we are in a system which is basically corrupt, where there is no planning and policy procedures. You might be able to get approval without going through the 100% legal way. Right. When that happens, anybody, now say for example, we all know there is a word called regularizing. But certain things you can regularize, certain things you can't. Because if you take the geographical conditions and the geo conditions, there are certain areas where a building cannot go more than three stories.
Yeah.
You can't take that weight.
Yeah.
So if you given permission to a 4-story, you can't regularize that.
Right.
There are certain things that you can regularize. Now, that negligence has that area of the law where public officials indirectly or directly are responsible for the construction or some area where negligence is the basis. You have to file action for damages.
Right.
That area has not developed to the extent that it ought to develop. That is one of the problems we have.
Right.
And
yeah, sorry, so just so that we don't have to revisit this, if an individual, let's say, now the same example could be taken to maritime regions where people are not allowed to build things too close to the sea. In that event, is it the responsibility of the officials to make sure that doesn't happen, or is it just the responsibility if they have given approval for that illegal establishment? How does that?
It's like this.
Yeah.
You know, in this country, everybody starts talking about rights, no?
Yeah.
But beyond rights, there's a word called duties also, no? I can have my rights,
Yeah.
but I will exercise my rights, have a duty. I must be mindful of my duties towards the other party also,
Yeah.
right?
Yeah.
That doesn't happen even among the public in this country. Everything is right.
Yes.
Right. So now, having said that, there is Coast Conservation Department. What is their duty? Their duty, they are for a limited purpose to conserve the coast.
Yeah.
You can't regularize something there. No? You have given permission. But what happens is now, by and large, we have got developed, we have started thinking, and the thinking after our mindset is, if a person has done it for 10-15 years, we should regularize. That is not the law.
Yeah.
That is not the purpose for which that institution has been created. If you really go around Sri Lanka,
You see a lot of these things.
you will see a lot of things which can't be put up or built if you really go through the Coast Conservation Law. So now, I think in a situation like that, it can be public interest litigation. It has to be public. Environmental groups and all are there. They could invoke public interest litigation and even take them to court on this basis.
Right.
If some damage happens, you take the Hantan incident.
Yeah.
I am not going into the facts of the case. If the permission, I am saying if the permission has been given wrongly, there must be some result. Now 1.5 years to 2 years have passed. I don't see that being flashed anywhere in the media.
Right.
It has died, in my view, a natural death.
A very important segment we just passed there, sir. We'll revisit this subject again. We'll take a very short break. You're watching Law, Line and Liberty. Stay with us.
Hi, I'm Rashan Jude Pinto and I am an independent researcher. My question is on the principle of vicarious liability. How is vicarious liability defined under Sri Lankan law and what are the provisions for medical negligence?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Kalinga Indatissa. It's a very interesting discussion thus far, and I think we're learning a lot of things. I have to single out one of these segments, which is the principle of vicarious liability. Now, even when you take law textbooks, a lot of content is separated for this, and I think you explained it very well in a concise manner within our second segment. But why is it such a complex area of the law? Because my next question is going to be on the medical negligence aspect. But vicarious liability, what are the certain maybe externalities that we need to discuss, the certain things that are included in it?
Vicarious liability emanates where I am responsible for somebody else's actions.
Right.
That is based on the bond or the nexus between me and that somebody else who has committed something wrong.
Yeah.
So that's why I said the easiest example to understand vicarious liability is taking the master-servant responsibility. Master-servant liability.
Yeah.
Master is responsible for anything done by the servant, unless the servant has done it outside the scope of his employment, or he has done it on a frolic of his own, where he goes his own rampage. So one of the biggest problems is where you marginalize these two, because there could be situations where the master and the servant could get together and outline a situation where the master doesn't get any liability and leave the servant or the blame to the servant, and there is nothing that can happen in terms of a money decree if that is separated. So that's an evidential matter, and that is one of the biggest problems that the practitioners of law face, because his evidence is not within the control of the plaintiff's counsel.
Exactly.
So that is, they can decide to give evidence or not to give evidence. But the question is, when the plaintiff has to prove that it is master and the servant, both are liable, master becomes vicariously liable, the evidential material and the degree of proof that you can put forward court depends only on, you can't summon them unless in extreme cases.
Right.
Defendant can decide to stay silent unless there is a case that is explained against him, which he has to explain now.
Right.
So that is one of the areas I find. And the same concept will extend to product liability instances also. You have the principal, the distributor, the agent, certain issues, but that's the problem. Unfortunately, the product liability area and the negligence that may arise in the manufacture of certain things has not been highlighted and not identified to the extent that this system should identify.
So before we go to medical negligence, something I want to clarify now. If the specific consumer product is something widely used, again, I don't want to go into specifics, and that causes death or that causes damages, that causes some kind of harm, does that fall on is it the best course of action to go for a fundamental rights case in that scenario, or should you hold the individual, the chairperson maybe, or the head of that institute liable for the negligence in carrying out their duties? Where does a plaintiff, where does a victim look into it?
Different types of actions are available. Now, for example, taking the same scenario that you just put out, if somebody is seriously affected by way of partaking a particular medicine or taking something, then what happens? The victim has a personal cause of action. That is to file for damages. Now, there have been instances, 25 years ago, I remember I did a case where the pharmacist had given the wrong injection. There was nothing wrong with the manufacturer. There was nothing wrong with the distributor. The pharmacist was asked to give, sometimes you cannot read the letters of the doctors, the prescription. Lawyers are not far behind, right? But be that as it may, the prescription was wrongly read. He gave the wrong injection and a baby died. The infant died. That was 25 years ago. So when you go to that mechanism, the question is, that in that instance, where do you draw a line? Whose responsibility is that? Pharmacist took up the position, I gave what was written. This is what I could read. But the matter ended there. Now my issue is, it's a complicated area. The laws have to be set out. It has to be streamlined and identified in a better way, so that this question of proof has to be made easy. Otherwise, the plaintiff, the victim, is going to suffer. That is one area. Secondly, if the particular product has been given approval wrongly, there could be a chance of you going for a fundamental rights based on the facts, because fundamental rights applications are made under Article 17 and 126 in respect of violations by the state only. You can't go for a fundamental rights against a private party alone. So, if the approval has been wrongly given, if you can demonstrate that, an approval need not have been given, there is no way that you could have given approval to a product like this. Then, you can challenge the granting of the approval either by a fundamental right or by a writ. But the question is, who can do it is the question. Now, Actually, when you go to this, you are coming into medical negligence, I will comment a few things. The segments of the country or the public are very poor people, not so privileged people who go through this process.
Yeah.
Those who have money can always get the best. Even if you go by the generic names, no, even the prescriptions,
Yeah.
they are generic. You will have the prescribed drugs or the medicine, but there are different prices.
Yeah. Yeah.
Same product, same generic name, right? So people who are affected in most of the instances, as I see, are the lower segments of society. So when they become victims, when they get involved in litigation, it's an enormous task for them, especially when you are suing a hospital or a doctor. So I think we should identify an easier mechanism of proof, what is needed, and and it has to be made easier.
Yeah. I think we are in a very strategic position to move into medical negligence as well. So now my question, I think when we were studying as well, the lecturers would say if medical negligence is too strictly applied, then the doctors will not have to go to hospital, but will have to go to courts every day based on what they are doing. So if we are to talk about medical negligence, and in this specific scenario, we are talking about physicians, how do you enter that subject, sir, and where do we give the doctor a certain area to work in, or even the person who's giving a prescription an area to work in, rather than holding them accountable in any scenario of a mistake? Is that the right way to go forward?
No, I totally agree with what you just said.
Yeah.
If you make it very rigid, then the doctors will be in court.
Yeah.
More than being in hospital.
Yeah.
Right. But there are some things that we have to think as a nation. Yeah. Number one, I have identified some of the areas which might be of concern. Number one, the concept of medical negligence is embedded in the concept of negligence. It's a further extension of the concept of negligence. But there are certain other things that you have to, additional things that you have to consider. Yeah. I have identified knowledge about healthcare, consumer consciousness of patients, patient's perception of whether a doctor had control over the adverse events. Do patients know of their rights? Duty of hospitals, reasonable care, professional skills, diagnosis and treatment, consent to treatment, post-operative care and nursing. Those are some of the key areas where one could claim that there is negligence. Now, I must tell you this. You just go by the Sri Lankan society. Most of them, they trust doctors with their life.
Yeah. They won't question the decision.
No. A doctor is like God. Yeah. And they don't have the knowledge to question that decision. Unless you are from a family where you can have access to information and also access to other medical doctors, you are not in a position. Now, for example, you depend on the doctor.
Yeah. They're in a position of power.
There is trust. Yeah. Now, in that context, if a blatantly wrong diagnosis or treatment has been given, there have been instances where that has happened, then there is something to worry about on the basis of negligence. Yes. Then the second thing is, what we have to realize is, it's extremely difficult. I know of several instances, because my experience is, I have been told, I discussed this. Yeah. If there is some violation or allegation made against the doctor, the hospital will stand by the doctor.
Right.
If it's against the hospital, the doctor will stand by the hospital. Sometimes most of these allegations I see are unfounded because lack of knowledge.
Yeah.
You imagine, you assume, because in the Sri Lankan context, when something happens, you go and tell a friend, he will give, who is not a medical officer, he will give more advice. That is how we think, how we react. Then you get fired up, then you think whether there has been a violation. There are instances where there have been violations. The problem is, the medical negligence can come in two ways. handling of the patient in all these areas.
Yeah.
Number one, if you don't put out the professional skill that you are expected to put out,
Yeah.
and also the professional skill on which the patient depends on you, the trust. Now, same thing about lawyers, no? Now, until maybe 20 years ago, nobody sued lawyers, but it's happening.
Yeah.
Professional negligence is the norm. Professional negligence is the norm. Now, there have been several cases where some lawyers have been disenrolled and suspended, right? So, sometimes I have seen in the newspaper, there again people go by assumptions and say that nothing happens to lawyers. No, that's not right. There are disciplinary inquiries. People have been suspended. People have been disenrolled for committing an act of professional negligence.
Yeah.
So, professional negligence is a matter for the governing board of the doctors.
Yeah. Right.
So, we at the Bar Association, we have certain powers. So, similarly, that is a matter of professional negligence is something that is when it comes to their license, continuance of practice and discipline. But if somebody has exercised professional negligence, that is a matter that can be taken up by the affected victim also. The experience that I trusted you with, the professional competence that you trusted you with, you have let me down. You are not acted in that way.
Yeah.
Then the second situation is, what happens? It's extremely difficult. Now, say for example, I get admitted to hospital, private hospital, let's say, and it's extremely access my documents. Extremely difficult for a victim's family to access the documents.
Yeah.
So, when the documents are not accessible, you cannot even identify whether there is a wrong prescription, wrong diagnosis. All those matters are in the realm where sometimes you might not even see. Right. Those are issues that I see in the medical negligence concept.
So I think you opened the window to quite a few sections that I want to ask in our next segment, where the reformation aspect is required. We'll take a very short break. You're watching Law, Line and Liberty. Stay with us.
Hi, my name is Shalindri and I'm a language and communication trainer at Move Colombo. My question is on the areas of reform. What are the key areas of reform for the laws of negligence in Sri Lanka?
Welcome back to Law, Line and Liberty. We are in our last segment and we are in conversation with President's Counsel Kalinga, Indatissa. So again, very interesting segment that we just passed. Now, when referring to the 9 points, I believe it was 9 that you established, I think it was quite informative to identify, okay, look, these are kind of the areas that we need to look at when it comes to medical negligence. And something I saw as an underlying feature was the education element that is required in all of this. People need to be aware, doctors need to be aware of where their entire power sort of complex lies. This segment is going to be particularly on reformation.
Yeah.
How can the law in these instances look into these very specific aspects, specifically when it comes to professional negligence? I think we, until we came to the third segment, we had kept that out for quite some time. How can the law intervene in those scenarios and really give more clarity?
All the professions have their professional bodies.
Yeah.
They have their own code of conduct, they have their standards.
Okay.
So if the standards are maintained, in the interest of the people and the general public of this country and the future of this country, I think every professional body, rather than trying to cover up any professional, should deal with the professional. You can impose punishments. So that is number one. Now the question is, professional misconduct or professional negligence can have an impact, especially when it comes from the medical profession.
Right.
Legal profession, you can claim damages, yes. Medical profession, if there is negligence, there could be a serious situation.
Yeah.
So, I think one of the things, now there are several issues. I think it should be made known to the people what options are available to them if they have a doubt. Now, I'll tell you something. I have handled with some of these people who allegedly claim that there has been negligence. But in fact, there has not been negligence. That is the perception that they have. That is something told by maybe a third party, or based on anger. None of us, if all the people in this country live with the fact that you will die someday, this country won't be here, what it is today. Yeah. Every morning when you get up, you think that you die. Yeah. So similarly, people in this country, they are very emotional. Naturally, they have to be if one loved person is affected. But the problem is, then you can't make an allegation against a professional without substantive material. You can't just make an allegation. Because sometimes I have had the opportunity of listening to these cases as a professional, as a lawyer myself. Now, the material that they come out with, somebody told me this. A nurse told me that the doctor got late by half an hour, and if he had come within that time, this patient could have been saved. Right? So when you can't go into that degree of questions, professional negligence involves some of the areas which I discussed. Wrong diagnosis, analysis, wrong medicine, being negligent at the surgery, post-surgery, post-medical care. All those things matter. It's not just minute areas where you can throw something in the wind.
Yeah.
Then the second question is, when it comes to hospitals, I believe the Right to Information Act gives you the right to claim documents. Nobody knows that. Only a few would know that.
Yes, I was about to ask you, when these documents, if they are not there, we need that for evidence.
Yes. Yeah. So there must be some regulatory system within the professional body. If there is an allegation, even a semblance of an allegation is made, take the documents into custody, protect them.
Yeah.
Right? Without leaving, because what happens is, if allegations are made, if the allegations are not proved, it doesn't matter. Otherwise, what will happen is the profession will be affected.
Yeah.
They will have to take the brunt. So that's all that I have to point out on that.
Yeah. And something that you mentioned is, this is important to hold the sense of accountability in all of these professions, because that is where the trust is kept. So about the reformation aspect, moving to the end of this discussion, I want to get your take. Maybe give us a brief outline of where we need to look at immediately when it comes to law of negligence.
One of the areas I have already discussed with you, that is, there must be this table of assessment of damage caused to an individual.
Right.
That is going by the accident cases. That is one of the biggest problems. The court will take a month or some days to come to a finding. How do we assess? Right? So we must have a mechanism where there is a table, identified mechanism, where a minimum value is placed, and from that, whether it is a villager from a village or a person from the city, it doesn't matter. There is a minimum value which is placed, then you work upwards on that. Second thing is, one of the biggest problems that we have is we don't have when it comes to criminal litigation, this country doesn't have a sentencing policy.
Right.
Okay? Now, what happens in this country? There is a roadside accident. Some people will take photographs from the handphone.
Yeah.
Media will rush there. The man in the vehicle will be assaulted mercilessly. That is what we saw. No? We have seen that in the last 3 months.
Yeah.
How people's anger come out. That is not the right thing.
Yeah.
So to me, it's tribal.
Yeah.
Worse than tribal.
Exactly.
Right? When an accident takes place now, what will happen is, accident is an accident.
Yeah.
The question is negligence. The question is negligence to which degree? If it's a mere matter of compensation between the parties, that's civil.
Yeah.
Otherwise, if it's a gross negligence that you were talking about, gross negligence, it is criminal.
Yeah.
So, the problem is, what happens is, even in criminal litigation, there is no sentencing policy. Right? Sentencing policy, if the law... Now, I have seen a lot of discussion in the Facebook, in the social media, in the newspapers, TV channels. Somebody knocks down somebody, and then there's a big hue and cry depending on who drove the vehicle or who was knocked down, either way. The simple question is, now it will take some years for them to go to court. Then after some time people will forget.
About it, yeah.
Even the media will forget because there will be other issues in a country like Sri Lanka, right? Then that is forgotten. But if there is a test, if there is a sentencing policy, was the driver drunk? This amount. Whether I appear, or whether the most junior lawyer who is called to the bar tomorrow, doesn't matter. The court will have the structure. People will have confidence. Right. Was he on the wrong side of the road? What was the speed? Examiner motor vehicles will examine and give the speed. Was the breathalyzer done? Yes. What was the content? Was he drunk? Yes. What was the content? What is the alcohol content? There is a difference between one glass and several glasses and being totally done. What is the alcohol content? You punish them. Then people will have public confidence. All these people rush into accident scene and try to assault the driver because they don't have confidence. And also the tribal concept. Right, that is all. Then there must be sentencing policy has to be introduced. Earlier, as I said, the table of damages. Then another one is medical negligence. There must be education. That cannot come in the negligence is negligence. Medical negligence is part of the concept of negligence. What is difficult is, it's much more difficult to prove for the reasons that we discussed. So we have to educate the people. What are your rights? When you go to a pharmacy, what do you do? What do you do? So likewise, your rights must be educated. That has to go on a countrywide basis. So those are the only three reforms that I can think of at the moment. Otherwise, if you ease off the proof element, rather than going into days and days of evidence, you ease off the proof element, then I believe there will be a speedier mechanism.
A more efficient mechanism.
And relief.
So a very interesting discussion. Always we can have this conversation for so much longer, but time will come against us. President's Counsel Kalinga, this is the former president of the Bar Association. Thank you so much, sir. It's a privilege to talk to you, and thank you for taking the time to come and explain all of this to us during these times. Thank you again. All right. Being firm on negligence is key to maintaining a country's productivity and the law and order. US General George S. Patton once said, "The discipline can only be obtained when all the officers are imbued with the sense of their obligation to their men and to their country, that they cannot tolerate negligence." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/Derana English. Join us again next week as we break down a contemporary legal topic. I'm Danidithan Vasa. Have a great night.